One, Mr. Stratton is charged with capital murder of multiple persons. Mr. Rapp
Well, Judge, I don't know that I nor Beaumont has seen.
testimony of the prior trial that I did preside over and argument by counsel. I'm going to grant the writ and set bail. I am going to find that bail in the amount of $1 million, but he's not denying that he was in the vehicle.
He was in the vehicle. He was, Your Honor.
The driver.
He was the driver.
Tired of guns, tired of people being shot, tired of it. Jefferson County's tired of it. I'm going to deny the motion. Your bond. Mr. Radford on, well, okay, you've got Lively Stratton and that's a bond hearing.
Yes, ma'am.
Do y'all anticipate that lasting very long?
No, ma'am.
All right, let's go ahead and take care of that. Lively Stratton.
Yeah.
Right, the bond go. Yes, Erica back. I don't know. If he might be in the back working on some of the other paperwork that Marvin. Oh, there he is. Marvin.
I've got one there at 11. Is that right? Okay.
I got my 9 o'clock docket in front of me. I guess there's a.
Yeah, that's it.
Yes, 11
I'll
o'clock
just
sentencing.
come back.
All right, sir, you're Lively Stratton?
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder of multiple persons. Mr. Radford has filed a writ asking for a bail reduction. I think we talked about this and reset it so that the state could bring any witnesses, and then I would make my decision. Mr. Radford, do you have any witnesses?
Yes, we call Lively Stratton for the purposes of this hearing only.
Best you can, sir. Please raise your right hand. Do you swear or affirm the testimony in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead, Mr. Radford.
Can you state your name for the record?
Lively Stratton.
And Mr. Stratton, you are the defendant in this case, is that correct?
Yes, sir.
And what is your bond currently set at?
I think after the appeal, I don't think my bond was ever set.
So it's your understanding that you have no bond at this time?
Yes, sir.
What was your bond set at prior to your trial?
I think it was $1 million bond.
Okay. And prior to this incident, have you ever been convicted? Well, you hadn't been, this conviction was overturned by the Court of Criminal Appeals, correct?
Yes, sir.
And prior to this incident, were you ever convicted of any crimes?
No, sir.
Where did you live at the time?
In Beaumont.
In Beaumont, did you have a job?
Yes, sir.
Okay, how long have you been incarcerated?
Going on 7 years.
7 years? So do you have any substantial savings or any monies that you have collected?
No, as far as my bond, everything would be no contributions from like from the family.
And if the judge were to set a $250,000 bond, do you think it's possible that you had family members and friends that could make that amount?
It'd be a stretch, but I think it'd be possible.
Pass away.
Any questions?
Mr. Brett, tell me about the means that your family has. What do your parents do? What kind of assets do they have? What kind of income do they have?
Well, my mom, she gets Social Security disability. My uncle, he's been a professor for the last 30 years. So I'm pretty sure he's got a good amount like saved up in travels and stuff like that.
Do your parents own homes?
No, ma'am.
Do they have cars? Does your uncle own his home?
He probably does as well.
And he's a professor at Lamar?
No, he lives in another state.
So would you agree with me that amongst the members of your family, you have considerable means to try to post a bond?
I wouldn't even say considerable because I mean, my uncle is really like kind of tight as far as his money wise. So it'd just be an if, even if he feels like doing it for me.
I don't have anything for you, Judge.
All right, thank you. Any other witnesses?
That's all I have, Judge.
Ms. Melfino?
Judge, I will call Detective Coffin.
Good morning, sir. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
And before beginning, Judge, I asked the court to take judicial notice of the trial that you presided over some years ago, which gave you obviously a very good insight into the totality of the circumstances and the facts involving this case, and that there were 4 victims of this case. So just ask Detective Coffin, would you state your name for the record?
My name's Frank Coffin.
And were you one of the lead detectives on the case State versus Lively Stratton?
Yes, ma'am, I was.
And that involves the homicide of 4 individuals here next to Lamar campus here in Beaumont, Jefferson County.
Yes, ma'am.
And you were involved heavily in the trial process, preparation, et cetera, and you know what came before the court. Is there anything that you would like to add for Judge West's consideration with respect to a bond being set for Lively Stratton?
Well, Judge, I don't know that I nor Beaumont has seen a murder like this before, where 4 people were gunned down so close to a college campus, so carelessly, so quickly. And I can't recall anything like that before. So I think that in itself states that's a significant event as far as murder is concerned.
Detective Coffin, based on all of your years of training, experience, investigation of homicides, et cetera, do you feel like Lively Stratton presents a significant threat to the community of Beaumont if he is released?
Significant threat.
And do you feel like they're, based on the totality of all these circumstances, there's a great likelihood of his flight if he is released from custody?
I would imagine that there would be, if knowing what he's faced with, knowing the amount of time that he'd already been sentenced to prison, the time that he can be sentenced again, there's no upside to not leaving.
I don't have anything further, Judge, unless the court does. From the detective, I just have a couple of statements for argument.
Okay, no, thank you. Thank you, sir.
Judge,
Oh, you
yeah.
have to ask questions. I'm sorry.
Detective Coffin, you testified at the trial, is that correct?
No, I
You
didn't.
did not? Did you observe the trial?
I did.
Okay.
Well, no, I did not.
So you didn't watch the trial and you didn't testify at the trial?
No.
Okay, so you don't know what happened at the trial?
I was not there for the day-to-day, but I do know what happened. I was here at the courthouse helping prepare with evidence, with witnesses,
But you didn't watch the testimony, did you?
with interviews. I did not watch the individual testimony.
Were you aware that the jury found that 2 of the victims evidently that they didn't convict him of killing the 2 guys with the knives? They convicted the 2 guys without weapons. Were you aware of that?
I'm not aware of the details of how many people or of how he killed each person. No.
Okay. That's all I have.
Anything else? No, Judge. All right. Thank you, sir.
Thank you, ma'am.
Ms. Malvino?
Judge, I would ask for a bond in this case that is equal with what the facts of this case are. The fact that we have 4 homicide victims. I think an ask of $250,000 is extremely low. I think it's offensive to the court to ask for a number like that for all 4 individuals, maybe $250,000 per individual. So that's back at the $1 million bond that he was originally set on. The court, unfortunately, is required to set bond on multiple murders in Jefferson County on a quite frequent basis these days. And I think something in excess of $1 million is more than a reasonable ask in this case.
Thank you, Ms. Malvino. Mr. Radford?
Judge, I would point out that the jury did find that there was evidently self-defense in 2 of the victims and that there was an error in the charge and that a new jury may find a different result based upon a new jury charge that should have been propounded to the jury. I think that the court should set a reasonable bond in this case.
All right. So taking into account the testimony of the prior trial that I did preside over and argument by counsel, I'm going to grant the writ and set bail. I am going to find that bail in the amount of $1 million is appropriate for the nature of this offense and in line with what I know about the case and the argument. If there was bond made, there would be a GPS monitoring device required and house arrest. I would obviously, if that bond was made, need to know what that address would be. And then we will get the case set for an announcement and then move it to the trial as quickly as any you guys are ready to do that.
Do we have a discovery
And Judge, I do have an update while we're here on it.
Sure.
With respect to discovery, Ms. Mayfield was very diligent in going through what we had, what we were able to locate on some thumb drives that we had made as just a backup in this case. Obviously, with the age of the case, et cetera, the court is aware of some of our hurdles we've had in recreating this massive file. Basically, we've also been working with Detective Coffin and BPD to make sure that we can get everything that is available to us to provide to Mr. Radford. I have done a spreadsheet type itemization of the media that I believe is there. What I would ask so that counsel and I are on the same page and make sure we both have the same things is that he would go through and itemize this in comparison with mine and make sure to let me know if he feels like there's anything that's missing. I will do the same now with this media itemization. I will go through and compare it to the hard copy file itself and cross over and make sure that we're not missing anything. But I do have 2 flash drives to turn over to him today. I also have spoken with multiple family members. And when the court has a little bit of a slower period towards that first part of March, we have meetings set up to meet with the family. I feel like I'm in constant contact.
Okay. All right. So yeah, if you guys will go through that, if there's any issues that you need me to get involved with for any reason, just let me know. Do you anticipate the time to go through some of that to get closer to where we need to be longer? You want to do a little longer?
Yes,
recent?
ma'am. I've got 2 big trials coming up in Orange, one at the end of this month and one at the end of February.
What I'll do is 60 days and let's just see where we get, start going through that media.
We do the end of March. I'm going to be going in April.
Whatever 60 days is, or make sure you have a vacation letter on file and we'll work around that and start going through it in the meantime so that when we get here, you've at least gone through and we know it better where we are on the media and the discovery and things like that.
Yes, ma'am.
Okay.
Thank you, Judge.
All right. You can go back with the bailiff. Thank you, Detective. See, Mr. Rojas, you have Brian Trejo. It's a bond hearing.
Good morning.
Good morning. How are you?
Good. How are you?
Good. Good morning. Are you Brian Trejo?
Yes, ma'am.
And this is 26 DCCR 0132. Mr. Trejo is charged with aggravated assault with a deadly weapon. Mr. Rojas has filed a motion asking that I reduce bond, which is currently set at 300,000. And Mr. Rojas, you may proceed.
So, Mr. Trejo, Your Honor.
Mr. Trejo, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can proceed.
Could you state your name for the court, please?
Sure.
What's your name?
Brian Trejo,
And Brian, how old are you?
18,
And where are you originally from?
Galveston.
You were born in Galveston?
Yes, sir.
Where do you live now?
Port Arthur.
You lived your whole life in Port Arthur?
Yes, sir.
Okay. Who do you live with?
My parents.
Your parents, and your parents are together and they're here today, right?
Yes, sir.
Okay.
Sorry, say that again.
They're here today, or his parents are here today. Who else lives in the house with you?
My brothers, my siblings.
And a lot of them are here today also.
So,
Brian, you know, your bond right now is $300,000. Your family's having a hard time coming up with the money for that bond, right?
yes, sir.
Okay. Well, as far, I want to talk about you personally. Do you own any property in your name?
Yes, sir.
A home, a car, any land or anything like that?
Yes, sir.
Do you have a bank account in your name? Okay. My understanding, and tell me if I'm wrong, your parents own the house that they live in, right?
Yes, sir.
And it's already paid off.
Yes, sir.
Okay. And they're willing to help you out as far as trying to get you get some money for the bond if we can go forward. Have you ever worked?
Yes, sir.
What kind of work have you done?
I work with my mom.
Doing what?
She cleans apartments, offices, houses.
Okay. Is that the only kind of work you've ever done?
No, the yards. I've done construction.
You did construction with a company or working with a family member or what?
Yeah, family.
Okay. And all that kind of work, the construction work, cleaning offices, is that work that's still going to be available to you if you're able to make a bond?
Yes, sir.
Okay, and that's something you want to get back out and start
Yes,
working
sir.
to help pay for the bond if we're able to get it lower.
Yes, sir.
This is a serious charge, right?
Yes, sir.
Is this, you're only 18. Is this the first time you've ever been arrested?
Yes, sir.
Even as a child, you have any juvenile cases? As a juvenile, were you arrested?
Yes, sir.
For what?
Unlawful carry.
Okay. And you're asking the court to lower the bond. We're asking for a $50,000 bond. I think that'll be enough, and along with any, if the ankle monitor or any kind of other conditions that the court wants to put on it. You're asking the court to do that, set that, and you think that's a reasonable bond, right?
Yes, sir.
Okay, I'll pass the witness, Judge.
Thank you, Mr. Rojas. Any questions?
What else were you arrested for as a juvenile?
Is it
Drug case?
possession of marijuana?
Yeah.
Speak up, please.
Possession of marijuana.
Thank you.
And what kind of weapon were you carrying when you were arrested as a juvenile?
Um,
Was it a handgun?
yes, sir.
And that's what you're charged with here is for shooting somebody. Correct?
Yes, sir.
Another question, Your Honor. Oh, sorry. What happened in the jail Saturday or Sunday?
Oh, I had got on the phone. Well, somebody passed me the phone, not knowing. Well, I didn't know somebody else was in line. Well, they forgot somebody else was in line. And while I was on the phone, somebody just came up and started punching on me.
The write-up was from the 8th, Your Honor, so you may not have had a chance to see it before court.
Okay, thank you.
And I'll pass those.
All right, anything else?
No further question.
Any other witnesses?
No, Your Honor.
Mr. Rojas, go ahead.
Yeah, Judge, I understand this is a serious allegation. He's a young offender, and obviously the handgun gives concern, both two different cases with handgun, and I understand the court's concerned with that. He's a lifelong resident of Port Arthur. He's not going to flee. He's doesn't have anywhere else to go. His family lives there. They own property. They own a home that they live in. They're not going to go anywhere. We think if you set the bond at $50,000, that's something the family will be able to make. And if it's at $50,000, they also, I would imagine the court's going to want an ankle monitor on this, and that's something that allows them a little bit of money to pay for the ankle monitor as well. You can set it at $50,000. And that's what we're asking the court to do.
Thank you, Mr. Rojas. Mr. Nichols?
I don't feel that $50,000 is sufficient to protect the community for someone who's been arrested for carrying a gun and is accused of having shot somebody at 3 o'clock in the morning. The allegation in this case is that he and some other individuals followed a young woman home from her place of business where she worked as a waitress and were harassing her, and then ended up shooting her boyfriend who confronted them. So I think $50,000 is quite low and not sufficient enough. Your Honor, I'd ask that you said something much higher.
And I understand those are the allegations, Judge. Obviously, Mr. Trejo has a different story, and I have watched the video, and I don't think that some of the statements the police officers got are not in line with what's on the video, but that's just something that will come out later on, as far as who the actual shooter was.
Okay, but he's not denying that he was in the vehicle.
He was in the vehicle. He was, Your Honor.
The driver.
He was the driver.
Okay. The question is, I guess, and from all y'all's perspective, is who was the shooter, but he was
Yes.
the driver.
He was the driver.
So I am taking judicial notice of the court's file, which includes a copy of the probable cause affidavit. The fact, Mr. Trejo, that you've already been arrested as a juvenile, which wasn't that long ago, because you're what, 18 or 17 right now?
18.
18. And I'm not sure what you were doing out at 3:30 a.m. In this situation, but it gives me great concern. Tired of guns, tired of people being shot, tired of it. Jefferson County's tired of it. I'm going to deny the motion. Your bond will remain at $300,000. If it's not already a condition of your bond, I am now making it a condition of your bond, if you make it, that you will be required to wear a GPS monitoring device and be on house arrest, if you're able to make that bond. And we'll reset the case for an announcement and get it taken care of as quickly as we can. Email back with the bailiff.
Thank you, Your Honor.